uh, you're basically implying because of how the law is written that AOT or civil commitment would benefit the person, but you're not saying specifically what treatment they would benefit from. It's not our role as the law is written and what the purposes of this are in the moment to assess whether or not treatment is feasible or practical. It is merely do they meet the eligibility criteria for it in general. So how you do this, again, because criteria one is as the result of a mental disorder. Is there a mental disorder? We're going to focus again on deficits over diagnosis. The AOT criteria, the civil commitment criteria, do not explicitly require a DSM diagnosis of a psychiatric disorder. It says of a mental disorder. That is broad enough that you can focus on the impairments and talk about categories or classes of disorders. An unspecified psychotic disorder, focusing on those symptoms rather than they have schizophrenia. Assess for the presence of psychopathology. You're going to do that as you would during a competency exam. Again, you can still focus on those broader impairments. It may constitute testing. You want to rule out substances, medical causes, other factors that could explain the impairments that you're seeing. But you're going to be screening for these in your competency examination, and that would be expected to directly translate as you get into AOT and civil commitment recommendations. In terms of compliance, you can talk with the examinee during your competency interview about past and current treatments. Have they been recommended? Has there been a time where they've been told or recommended to go to treatment, but they didn't do it? Tell me more about that. What was going on? What were you recommended? What were the reasons they didn't do it? See if there is a demonstration of noncompliance. Do you have a timeline where we have evidence they were hospitalized in 2023? And in 2023, like say a couple of years ago, I was told to do this, but no, I've never complied with medications because I don't believe in medication. You have a timeline now of noncompliance around that time that with a key role in a hospitalization. And you want to ideally get those records that would substantiate that even further. But again, do you have enough to say there's clear convincing evidence that noncompliance played a role in their hospitalization? What is their insight? What is their history of insight into their mental illness? Are they explicitly refusing, or are they otherwise more passively disinterested in treatment? Asking them and getting to know what are the circumstances around when they got locked up, the recent hospitalizations, understanding any possible connections to mental illness, any treatment that was going on around that time, or any treatment that was recommended, and were they engaging in it? Any jail records, hospital records, collateral interviews with staff, family interviews that can give you more info about community living, particularly if the self-report is insufficient. The criminal complaint can sometimes give you hints about, particularly if the parent or somebody well known to the defendant is one of the victims or witnesses, and they report in the criminal complaint that so and so noted the person has schizophrenia and wasn't taking their medication, which I've seen in criminal complaints before. Um, do we have some documentation that says, oh, right around the time they got locked up here, there were people that expressed concern that they had this significant mental health issue and they weren't taking their meds? Again, we have to connect this to noncompliance with mental illness. And that is, I think, in my opinion, that is the biggest obstacle in terms of somebody appearing to meet criteria, having clear and convincing evidence of meeting criteria, is this connection for AOT eligibility at least, between institutionalization and specific non-compliance with mental illness, not merely showing symptoms of mental illness. The person must also demonstrate a significant risk of harm to self or others as a result of this mental illness. You're going to assess for past behavior, relationship to symptoms, how similar are current symptoms to past symptoms when they have engaged in harm to self or posed a significant risk of harm to themselves. Any ongoing thoughts that suggest ongoing risk of harm to self or others, and any relationship between that and their current psychiatric impairments. Do they have immediate access to weapons and other acute considerations that would be relevant to their likelihood and potential danger to themselves or others? Past violence, current threats, access to victims, emotional control issues. These are substance use, delusions, hallucinations, urging or supportive of violence. I bring these up to highlight that at least for psychotic symptoms, even hallucinations and delusions do not inherently increase people's risk for harm to other people. The hallucinations, we see relationships with aggression if hallucinations specifically are related to commands to urge violence or commands that support engaging in violence, but many command hallucinations are not violent in nature. And delusions, it can depend on both the type of delusion and the corresponding emotional experience, which some recent research has suggested to us. So, for example, even if somebody has persecutory delusions, fearing that people are out to get them, if this leads them to feel primarily scared and inhibited, that doesn't inherently increase their risk of harm to others. But if the persecutory delusions result in them feeling angry about others, or fearful for their lives in a way that elicits an urgent need to eliminate that risk, then it can increase risk for harm to others. The time frame we're being asked to assess, this is different than risk of harm to self or others in terms of mandated inpatient hospitalization, because that focuses more on immediate danger, acute. That can certainly be present here too. Acute would fall under this, but the time frame is the near future. So imminent risk would fall in the near future, but it's not necessary. Our long-term 5-year risks, that could be informative, but not necessarily sufficient. I will say, there is not an explicit time frame that's been told to reference. You can keep in mind that AOT is designed for a roughly 90-day window of treatment to address risk of harm for self or others. Um, so we're talking more than the next couple of days, but we don't have to go as far as several years down the road. Uh, Past success in AOT. Things in determining is AOT the least restrictive means. Have they done AOT in the past? Have they done outpatient treatment in the past? How have they reacted to it? Have they complied with it? If there is demonstration of non-compliance in the past, what is the reason for that? And are those reasons relevant or evident now? What is their living situation in the community? So, if we mandate this person to outpatient treatment, and they are supposed to go to a community mental health center every week, and we are going to attempt to get, you know, contacts for appointment reminders or to schedule appointments. Are they contactable? Or is there reason to believe that once they are discharged from a detention center, it is likely to take months to find this person again? That there's no means of stable living and no means of contacting to identify where they're living. If that is the case, that increases the risk of non-compliance and sufficient monitoring. Are they actively refusing versus disinterest or ambivalence? So if they are expressing resistance to treatment during your interview, exploring how far that goes and what are the reasons for it. Are they making a deliberate decision that I will actively resist this treatment? Are they more, if it were my choice, I wouldn't do this, but if they were forced to, they would comply because they don't want to get in trouble? Or are they more just nervous, ambivalent, otherwise conflicted, but there's no indication they would actually refuse? One rule of thumb for thinking about AOT being the least drastic means is if this person were in outpatient treatment, would that be sufficient enough to identify people early on at the start of decompensation? Or are we saying the only way we'll be able to actually identify decompensation is once the person is fully at that point of hospitalization or acute immediate danger to self or others? If we have the potential to monitor the person where we could intervene, even if they decompensate, we're identifying them at the start of decompensation, um, that increases the odds that AOT would be sufficient in the least drastic means principle. As I said before here, eligible for treatment, we're not offering recommendations. We are merely saying, are they eligible by the statute? Again, you don't need to know if the treatment is available. You don't have to find the specific treatments or recommend specific treatments. And I have in here a number of different report written examples of how that would look. So you'll be able to use some of these as a guide. There's short versions, there's long versions. Um, and so I will take a step back now. Any questions, thoughts, considerations about assessing for um, mandated treatment in the context of these competency exams? Okay, well, with that, we will take a brief break. Let's convene again at 1:45. I have 1:41 right now. And then we will talk about testing considerations for about 45 minutes before we move on. All right, I have 45 after. So my goal is to end this part by 2:30 your time, going over some testing considerations. Again, much of this is what we went over in May, just a more condensed, rehashed version. I'm talking a little bit about response style as well here. There are a number of different constructs that are relevant to our competency examinations. When we think about the many different issues that could be relevant, the many different psychological constructs that could be relevant to somebody's poor demonstration of competency abilities, there could be a number of factors. Many people are non-competent for many different reasons. We're thinking about communication deficits. We're thinking about their ability to understand information, ability to make rational decisions, working memory to actually be able to understand, learn, and use information, abilities to process, control one's emotions, understanding of reality, and of course, their approach to the examination. These are all constructs that we can assess with a number of different ways, including with psychological tests. And so you are thinking about it when these constructs come up. Do I administer testing? Well, the most common reasons that we hear about people administering testing is because there is enough evidence for that testing to support it in that context, that it gives me credibility in the courtroom and in my report if I'm basing some of my results on tests. And it helps provide standardized data in the evaluation. It assures one, as far as an approach to the evaluation, that I'm administering something that in the same way that I would administer it to other people with similar kinds of concerns. And that when I talk about someone's levels of impairment or their functioning on this particular construct, I'm comparing them to a normalized sample where there has been a deep investigation into how they would be expected to perform and how the defendant lines up with that and how that can reflect their abilities. Now, reasons for not testing that have been cited. One, people saying, I have enough from what I clinically saw and the judgment, I have enough there that testing is not warranted. I simply do not have enough time. That could be, now I'm not saying the person saying I'm too busy in my work in general, but if we are on a 30-day window for these evaluations and it takes weeks to get an appointment with a judge, with the corrections center, or the person's outpatient and we're having difficulty finding the person. Sometimes it can be a logistical nightmare to administer testing. Or, the third most common reason people cite is that, well, what I would want to test isn't normed in this context, or it doesn't actually get quite at what I'm trying to get at here, or it's just there isn't the particular context that I'm in. There's not a test that I feel provides standardized information to inform in this particular case. So in considerations, decisions into considering when to test. One question is, what are you trying to test? What impairment have you identified? So thinking about what concerns do you see, and then what specific competency issues would be connected to this impairment. So if I see an impairment in terms of their level of despondency to trauma, and they've been diagnosed with PTSD, or I'm curious about whether or not they meet criteria for PTSD. But I determine through my evaluation that the traumatic event that they're referring to has no logical or apparent connection to their case and their attorney, then any potential negative emotionality related to the trauma they've experienced is unlikely to be connected to their competency. And so testing wouldn't be as informative there to test for the presence of meeting criteria for PTSD or not. Whereas if I am concerned about somebody's memory, that they might have memory impairments, and the competency issues I'm concerned about is their poor retention in the room with me about some fairly basic legal information, then now suddenly memory testing could be quite relevant if we've identified an impairment and connect it to a specific competency related concern. Number three, do I currently have insufficient data to tell me that there's enough evidence that that functional impairment is there. So I don't have prior testing. I don't have enough information to be clear that there is a scope of these impairments that rule in specifically this kind of level of impairment. Um, I have data that says that they were diagnosed with a developmental disability, but I have insufficient data that informs me the actual scope and nature of those deficits. Once I've hit those three, now I'm going from is testing reasonable as a concept to is testing reasonable in practice. So number four gets at what tests are there available that actually address what I would want it to address. Is that test appropriate in this context? So I want to test a construct. I don't have enough information that suggests they meet this kind of memory impairment. Is this memory test that I'm looking at, is it appropriate to use in a correctional setting? Is it appropriate to use in a competency exam? Or the other way you could look at it is if there isn't explicit information that it is recommended or that there's evidence for it used in this, is there a conceptual reason that would suggest concern that using it in this context would be inappropriate? You want to think of both sides of the coin up there too. Do I have evidence? Is there evidence that substantiates its use in this context? And if I don't, is there a reason to believe that that absence of evidence could be a concern? Is there a reason that it might not translate in this context? So thinking about the competency related abilities, you might have you might have some context where you say, oh, well, technically, this test hasn't been normed on people in jails in New Mexico, but it has been normed on people in jails, in detention centers in other states. Is there a reason that we would be concerned or expect the generalization to New Mexico to be compromised? If not, you could likely consider that test nonetheless appropriate for this context, that the context is more about testing this within the confines of an institution rather than an institution in this particular state. And then similarly, is the test appropriate for the examinee? This is where you get into, is the test supported for the person in front of me? And if not, are there reasons that there could be differences? So at the example that I think just came up in the chat about normed on Native Americans. So you want to connect the lack of norms with Native Americans to then why, if Native Americans were not represented here, how administering this test could be misleading or result in less valid information. And one reason could be if we are considering familiarity with the legal system and we're assessing that, and we know of critical differences of people on reservations, and this person lived and lives on a reservation. We might be concerned about how base levels of legal knowledge understanding and legal knowledge retention, how the normative sample and what data are provided there actually map on to a standardized comparison for Native Americans. Again, will it help us? Will the results that we get map on to the context and the person that we're assessing? And if you can say yes to these, then we can proceed with testing. Potential reasons to not test. Do you already have enough to establish that impairment is there at the level that you need? Can you already connect that impairment to specific competency-related abilities? Has the examinee, quote unquote, failed performance validity tests, which would then elicit concern for us about whether or not administering any additional tests would actually represent their abilities. Is the examinee acutely psychotic and you're trying to assess cognitive or neurological or neuropsychological functioning? If they're acutely psychotic, then if you're trying to assess for the purposes of establishing a cognitive impairment, it might not actually represent that. Has the examinee recently done testing with practice effects being relevant? So you'll want to have that knowledge of if an examinee's recently completed testing. But if someone's done an effort test in the relatively recent past, it doesn't necessarily disqualify you from using that effort test in the future because the effort test is not designed to tell you their precise level of legal knowledge or legal understanding or whatever the test is assessing there. It's assessing are they giving enough effort? That's okay. That's okay if they've seen that before. If it were actually what is their baseline legal knowledge and their abilities to remember things, now practice effects might be relevant. This is where we get into memory and cognitive tests in particular. And then are there language, cultural, normative issues that again suggest that the translation would be misleading or any other logistical issues to administration? Um, you know, particularly if the person is incarcerated and you're trying to do things remotely, often that'll be a logistic barrier for many different types of tests that we attempt to administer. Different testing categories, clinical assessment, forensically relevant, forensic assessment instruments. Most of what we use in forensic examinations are more forensically relevant than actual forensic assessments. Forensic assessments are those instruments or tests that directly connect to the psycholegal question, whereas forensically relevant tests are those that can commonly be used to make inferences about forensically relevant constructs. So the example you'll see there I have is response style. A response style, a response style test is forensically relevant because we use the data from that and other sources to infer on response style, which then we use to inform on the psycholegal question, providing their effort or potential feigning in the context of the other data I have. But a response style measure will not tell you, will not conclude the person is malingering, and it will not tell you whether they are competent or not. It won't directly answer those psycholegal questions, but it will provide you it can provide you information that will help you as you get closer to understanding and addressing the psycholegal question. Now, in terms of here in New Mexico, data that is admissible, um, where the New Mexico rules 11702, I think Randy talked about this last week, so I'll pass over this. Basically, we're in Dalbert, Albarico state, relevance, reliable methods, reliably applied to the case, things, and the Dalbert principles here. I'll assume background there. Here are some of the most common types of forensic tests that are used in forensic evaluations. Now, these data are 20 years old now, so there's an important caveat there about taking these results here literally, and it's very distinct that some of these results have changed, especially for tests that have come out within the last 20 years. So we don't see any selection effects differing by training. Um, in most recent surveys of forensic examinations, forensic psychologists, roughly 58% of those said they used testing and competency examinations. They used multiple of them. And in competency exams, the most common tests reported are the WACE, the TOM, the MFAST, the MMPI, and then we finally get to a competency specific measure, the EXTER being the most commonly used, at least when um, Tess Neal and Tom Grisso reported this in 2014. Since May, I have heard back from Tess about she's actively doing an updated study on what testing forensic psychologists use. She said she's not at data analysis yet, so she doesn't have enough yet to know how well things are translating from the study 12 years ago. Testing administered in court. The take home here, we've had some concerns about the tests that forensic psychologists have used in a number of forensic assessments, many of them not seeming to meet the basic Daubert standards when we look at the psychometrics and data that are available. And yet, test validity is very rarely challenged. So you have this disconnect. Um, I forget the exact title of this article, but it's to the effect of is junk science being allowed in the courtrooms? And the overall conclusion is it appears to be. If you determine junk science being those that do not meet the criteria for if we challenged it to admissibility, that roughly only 40% of those that are reportedly used by psychologists seem to actually meet that, and yet actual challenges to that admissibility being present in only about 2.6% of cases. So the vast majority of the time, these tests that aren't meeting the standards are nonetheless being admitted into court. These are state data that says we use a number of different cognitive and response style tests. All right, getting to some of my mindset related considerations in testing. It's important to prepare before you administer a test what you actually expect to find from it. The reason I say that is that it is important for us to reduce the odds that we are going to interpret testing results, especially ambiguous results, in ways that support what we wanted the tests to find for us. We want to think about ahead of time, how useful are the results going to be, and thinking about what I expect to see from them. If the results are this, that would lend support to interpretation one. If results are this, it would lend support to interpretation two. It doesn't have to be as far as this is my cutoff score. And in fact, in many times that would be inappropriate to say like, oh, if it's a score of 70 or below, then it's this. And if it's a score of 70, if it's a score of 71 or above, then I'm going to say that there's no impairment and they're competent. You're considering the overall scope of data, but saying based on your concerns, get as specific as possible in thinking about what you expect to see from this test. The WACE, of course, has many different subtests and different domains that are assessed. You don't want to just broadly say, I have cognitive concerns, so I'm going to throw out a WACE, and then just look at the test for any evidence of any kinds of impairments. You want to be mindful of what impairments am I actually seeing? What tests and domains on the WACE are relevant to the impairments I'm seeing? And that tells you what you expect to see. if you see impairments in this particular domain, that would strengthen the case that the concerns that you have are based on an impairment that is informing on those abilities broadly. Rather than, oh, there's an impairment, and therefore, just like I said, he would have some cognitive impairments. Um, so this is the Dr. Ponder example that I brought up in May. Again, I've seen this in many different reports before, where somebody opined a person they had some cognitive concerns, and they said cognitive testing results showed impairments. They defined them as not competent, and noted some of the concerns were supported by their cognitive testing, but the actual impairments on the testing didn't map up with the exact concerns that they had reported seeing. They need to match up or at least be consistent with the functional concerns that you're seeing if you are going to say that testing supports functional impairment. So if processing speed is shown as impaired on this test, but processing speed was not relevant to your concerns of competency, and in fact, you show no concerns of processing speed efficiency in the person's responses and their decision making. And instead, where you're concerned is memory, but the tests don't show impairment on memory. I'm not saying that that means that the person's competent, but the testing is not supporting memory concerns specifically. You would not go as far as saying cognitive results support this idea of impairment because your cognitive tests did not actually support the impairments that you were seeing. They just both fell under the same broad category. And that's why I encourage people to think about ahead of time what the wealth of information that can come from the test you want to administer, and ahead of time thinking about what areas are most relevant to the concerns I see. It doesn't mean if you see other concerns, you have to disregard them. In fact, it might encourage you to reflect on, did you see those deficits, or is there information from deficits elsewhere? And now we get into, as referenced, and we get into a little bit of response style stuff. I wanted to just emphasize in the response style area. I want to emphasize two particular things. The first part being that response style is we are assessing in a forensic context, we are assessing two different constructs when we refer to a response style. One element of response style is effort. Effort is continuous. It is how much somebody is applying themselves toward a particular goal. It is not a yes or no thing. It is how much effort is someone giving for a particular cause. So we're not saying somebody is giving no attention. Maybe we can argue that if they're unconscious in the room, but inattention is more reflective of a low effort or a poor intensity of effort. It's not an absence of effort. Psychological disturbance is not, do they have depression or not? The BDI has categories on it, but the BDI doesn't have a cutoff in a general context. If we're talking about dimensional stuff, the BDI doesn't say necessarily do they meet criteria for major depressive disorder or not. It's more dimensionally focused on the intensity of symptoms. When we talk about response style issues with psychological disturbance, we are talking about their effort to relay credible, valid psychological disturbance information. But psychological disturbance can also factor into effort. Distraction from internal stimuli can affect how much somebody is applying themselves to give correct legal knowledge. Somebody could just not be trying. Somebody could be upset with you. All of these things can factor into effort. And then the other factor is motivation. So effort is about the intensity of how much they're applying toward a goal. And motivation is, what is that goal? That is more of a description. This is, do they want to do well? Do they want to do poorly? This is about intent. So, two related but important constructs when you're considering response style. And I'll give some examples that should help with that. Um, but also, when we think about malingering here, when we think about malingering in a forensic context, it must be intentional. So that gets at the intent part. It must be exaggerated, and there must be a motivation for external gain. So it is not sufficient to say somebody did poorly and they did so deliberately. You are saying intent, they did poorly deliberately, and they did so deliberately to achieve a particular purpose. So here is a hypothetical here I want you to think about. Eliza answers basic questions about her, like the jobs that she's had, but she just shrugs or says she doesn't know to most questions you ask her about court. When she does this, you prompt her to, think about it, give your best guess. But she looks frustrated, said, I already told you, I don't know. You decide to pull out a forced choice test of legal knowledge. She goes, I don't know, to most items. When you say, she says, I don't know, you say, choose the best option. She rolls her eyes and eventually responds. So she does give you, when you say on these forced choice, choose the best one. She rolls her eyes, but she does actually give you a response. Her results on the forced choice test are well below chance, so low that the odds of it being random responding are 1 in 200,000. Is this person malingering? While you're doing that, I'll read Randy's thing here. You're right, Natalie. We have insufficient information to actually say that this person's malingering. Now, we might suspect that they are. We have compelling evidence that suggests they have more knowledge than they were sharing with us, and that they also deliberately responded incorrectly to questions that they knew the answers to, given how poorly they did. But again, malingering requires motivation for external gain. What if Eliza is just pissed off at you because she told you she doesn't know stuff and you keep pushing her? And so she says, I hate this person. I am going to sabotage their examination. And she's not thinking about, I am trying to trick this person to be found not competent. But she's saying, I don't care about you or your examination, and I want to sabotage it. That's not an external gain. And so that would not be considered malingering for these purposes. So again, I bring this up just for the preciseness. Rule out everything else before you necessarily rule in. Randy's chat comment in here, I encourage all of you to read it you can think of odds ratios and false positives in tests, and I'm thinking, man, 7 measures of response style. What are the odds of not meeting the criteria for one of them at random? And were all those tests done the same day? Somebody exhausted at some point? How may that factor into their response by that point? And it seems like somebody generously either an overly conservative approach, or somebody who was motivated to be hesitant to highlight stuff. All in the same session. Okay, so and effort can wane over time, especially if you're asked the same questions over and over and over and over again in the same 5-hour session. It's also a 5-hour set. That's very long. Okay, yeah, you could see there are a number of factors of why someone could ding on 1 out of 7 tests, even completely at random. Um, Distinguishing between performance validity and symptom validity. Is performance validity is more about cognitive performance. It's about abilities. And symptom validity is about your active endorsement and how likely that is to be a valid representation of what you actually perceive and experience. So performance is more, I'm doing something here. How well am I actually doing and it being reflective of my abilities? Symptom validity, I'm reporting what I experience and how likely is that to reflect what I actually believe or what I actually experience. Here's where we get into effort and motivation again here. If we look at the Tom as an example here, effort is intensity. You can give extremely high or extremely low effort. The poor is this middle area where there's low effort. But when we get all the way to the extremes here, when we get to below chance, that's when we actually, even if somebody performs very poorly, that doesn't map directly on to poor effort. In fact, somebody can perform so poorly that it actually evidences high effort to do badly. So that's where the motivation, the intent and the effort come in. So to perform all the way at the negative extreme actually requires effort, but it's what is the intent of the person? And there it is effort to do poorly. At the other extreme, we would say there's enough effort to do well. It's that middle ground area where we're saying insufficient effort. And these things don't always map onto each other. So as you know, there are different domains, and you can think particularly for competency examinations, there is effort and response style related to general cognitive abilities, your memory, your comprehension, your effort and intent related to psychiatric impairment, and your effort and intent related to specifically legal knowledge and legal decision making. So, as an example here, Jim is intermittently cooperative with your evaluation, is very short. He says, I don't know, I can't remember to a lot of things. Um, on the Tom, he performs at chance levels. He endorses nothing on the MFAST. And then on the ilk, he does above the cutoff. So there's a number of reasons that we could see this, but if we said, what is his response style? It depends on what domain we're talking about. So This is someone who performed poorly in the area of random responding for general cognitive issues. They were saying, or at least for memory, but they seem to be putting in enough effort to do well on psychiatric impairment and on their actual legal knowledge. This could be an example of somebody that bombs the Tom and says, I don't know, because they don't see the point in trying on something that they don't see at face value is relevant to why you're pulling them out of their cell. You said this was about court. So when it's court related stuff, I'm paying attention. But when you're asking me, oh, do I remember seeing the pitcher or the toaster? Who gives a crap? And not really paying attention to that. So just because they bombed the Tom doesn't mean they're malingering or feigning impairment. You got to consider what the domain is and how much effort they're giving and what that intent of that effort is. Whereas here, Jane is consistently disruptive. She endorses every difficulty under the sun and spontaneously volunteers bizarre content throughout your interview. Her Tom is below chance levels. The SIRS is in the definite feigning on 4 subscales. She does a 16 out of 61 below chance on the ilk. This is an example. Again, we would not say this person is giving low effort or poor effort, rather. They're giving much effort to do poorly. My final take homes for this response style stuff is remember that there is a difference between feigning and malingering. Malingering requires that motivation for why someone would be feigning, connecting it to an external reward. People can inf People can feign in competency exams for reasons other than to try to get out of trouble. And I also want to emphasize here that if you determine somebody was feigning, shoot, if you determine somebody was malingering, it doesn't directly translate to that person being competent. One, feigning the nature of an impairment doesn't mean that no impairment exists. It's merely about the credibility of what they are reporting to you. It doesn't mean that they are not, that they have no impairment. It doesn't even mean that they could have impairment but only have mild impairment. It only tells you that the level of impairment that they are reporting does not translate to their actual abilities and in fact might be deliberately not translating to their abilities. But people can also have multiple impairments. People can choose to feign psychiatric deficits and have genuine cognitive impairments. And people can also choose to feign confusion and cognitive deficits and have genuine other cognitive deficits or other psychiatric impairments that nonetheless render them not competent or compromise their competency abilities. So I I urge you to take a step back if you see compelling evidence of feigning, even if it's deliberate, that doesn't automatically translate to finding the person competent. This can be an and scenario. Yes, the person was feigning, and I have concerns about their competency abilities. Yes, and not referring to all of these of effort tests is true. That's why response style, because effort is one domain, intent is the other. And people, when we say poor effort, sometimes people mean effort to do bad, and that is in fact the exact opposite of poor effort. Effort to do poorly and poor effort are different constructs. So with that, I'm going to fast forward through all of this with you some interpreters, all that. All right. So that's where I am going to wrap up this testing portion. I have 3:26. I will stop sharing my screen and we will convene at, oh, I have 3:26 because I'm in Central Time. You have 2:26. We will reconvene at 2:30, and then Randy will take the lead on discussing reports and testimony.
So if you can maybe stop sharing, Anthony, and then I will share.
Oh, I just pressed escape but didn't actually stop the share of my screen? Or is my
Well,
screen still?
I don't see your, if
Okay.
I don't
So
see, okay,
I did stop share then. Yes.
okay.
Okay.
Give people a couple more minutes to relax before we get into this. We have 2 hours left in our session, and just in terms of the agenda, I'm going to talk in some detail about how we communicate our work, writing reports and testifying, and then Anthony and I are going to attempt to do a mock competence hearing with Anthony uh, playing both the prosecutor and defense attorney. Uh, and I'll talk more about that defendant and evaluation once we get through some of this lecture material will be certainly done uh, by 4:30, and then everyone can uh, complete the examinations and then do whatever else they need to do in order to get their certificates reflecting training. And we'll make sure that we post the link in the chat for you to do that. Just a reminder as well, make sure that you sign out at the end of the day in just a couple hours here coming up, and then you can all get to starting your weekends. So let's talk a little bit about writing reports and testifying. They're both ways that the examiner communicates a number of things: who the examiner is, how the examiner was involved in the case, uh, what the issues were that the examiner addressed, information that the examiner was provided, along with information that the examiner either generated or collected himself or herself, and then ideally opinions and underlying reasoning. But communicating those same kinds of things, either orally or by way of writing, different. In my experience, uh, for every time I testified, particularly in a competence matter, every time I testified in a competence matter, I probably had conducted 20 examinations. There was liberal use of attorneys stipulating to reports in the jurisdictions in which I practice. So testifying was the exception rather than the rule. Report writing was not the exception. It was essentially the rule, as is the case if at least if you're conducting these evaluations by way of appointment by the court here in New Mexico. Uh, when we're writing reports, we're in complete control of the process, right? No one's looking over our shoulder. No one is really in control of what we decide to exclude or include or what we decide to address. It's very different when we testify, at least insofar as we only get to answer questions, we only get to address issues um, that are in response to questions that other people are asking us, specifically two attorneys and sometimes a judge. I was referencing that yesterday I testified remotely in a hearing. It was a California courtroom, but I testified remotely here from here in New Mexico. And the judge was a very active judge and was asking a lot of questions. In fact, the judge asked more questions than the defense attorney. I was called to testify by plaintiff's counsel. So because the examiner's in control of the report writing process, he or she determines what is shared, how it's presented, etc. And we are pretty much left to the devices of attorneys um, by way of the questions they ask in terms of what is shared. We might be dying to share a critical piece of information and think it is the most important piece of information for a judge to hear about in a competence hearing, but the judge doesn't get to hear about it because we weren't asked the right question. Uh, Tom Grisso, a very accomplished psychologist, once was talking about writing reports and testifying, and he likened writing reports to painting a masterpiece. Having all the time and the luxury of taking your time and revisiting and reconsidering and walking away and coming back. He said, but testifying is very different. He said it's more like graffiti on the sidewalk, in that it's shorter and there's not a lot of time for reflection or deliberation, or there's no such thing as revision unless maybe you get to readdress an issue during cross-examination or redirect examination. And I think everyone in our training appreciates that writing reports considerably less pressure, considerably less anxiety than getting up on a witness stand. um, well, first question, should the examiner write a report? In New Mexico, court-retained examiners are required to write reports summarizing competence examinations. Non-court retained experts are not required to write reports around matters of competence. They should probably, as a result, look to the retaining attorney for direction after completing the examination. Just to sort of paint the whole picture here, I'll point out that some jurisdictions require any expert, no matter who she's working for, writes a report or she doesn't get into the door of the courtroom. The best example are Federal Rules of Evidence and Federal Rules of Criminal and Civil Procedure. You don't get in the federal courtroom as an expert unless you wrote a report, unless some very minor, minimal exceptions. And I don't think there is any jurisdiction that is so focused and specific about what must be in those reports that the experts write, whether they're mental health professionals or others. What are the advantages of writing a report? It's probably the most efficient way to communicate to someone what you did, the data you had, the data you didn't have, what you learned, what you concluded, the underlying facts, and your opinions. I don't know how you can do it any more efficiently or effectively than by writing a report. My experience, you can all decide for yourselves, writing a report really helps me organize my thinking. It's not until I actually put my fingers on the keyboard and start putting onto the screen all the facts that I think need to be considered. It's not only until then that I do the very focused job of weighing and balancing. I can do an evaluation and be driving home, and as much as I think that I'm doing a similar job of weighing and balancing and comparing and contrasting all the relevant data, it's not near as effective as when I'm actually writing the report, whether that's pen to paper, although no one does that, or whether it's fingers on the keyboard. It memorializes the opinions and it makes explicit what the person's opinions are. So nothing real. I mean, if the report is written with an intent to be communicative and not engaging in shenanigans like keeping things vague, if the report is written in the spirit reports are to be written, which is efficiently and effectively communicate a whole bunch of things, it memorializes opinions and commits the report writer to the opinions. It's a lot harder to dance around and do the two-step to change your mind or realize that that might not have been something that should have been said. Much harder to do that when you've got a hard copy of a report. Reports can be useful to attorneys in terms of crafting direct and cross examinations. After all, again, if you're writing a report like a report should be written, you're laying it all out for them. Based on what you believe is most important and significant and relevant and all of that, but you're laying it all out for them. And I think you'll find in many cases, the direct and cross examinations to which you're subjected are shaped, at least in part, in terms of how you wrote the report. And another benefit is that it identifies possible problematic evidentiary issues in advance. And if you remember to my discussion last week of some rules of evidence, some rules of evidence preclude certain kinds of information being presented or being considered for deliberation in evaluations. And if it goes in a report, that can alert people, wait a minute, we've got a potential evidentiary issue here. What do we need to do? Some general issues in report writing, and I'll say a lot of this applies to testimony as well. And I'll reiterate what I said last week, which is whenever we're evaluating people with the intention of talking about them at a later point in time and helping non-mental health professionals, judges and lawyers, and not in competence cases, but in other kinds of cases, jurors, whenever we do that, the rules of evidence say that we're there in order to help them understand complicated issues that we have expertise, specialized knowledge about, and we should communicate with the people we're trying to help, the judges and the lawyers. We should communicate in such a way that they understand it. So, as the most basic principle, jargon is either avoided or explained. I think I might have said last week in the training that when I train judges and attorneys about this, I had a workshop or a program that was titled Judges and Attorneys as Consumers of Experts' Products. And it was really about getting them to think about what they should expect from any expert witness. And that is complicated stuff. That's why you're here. If it wasn't complicated, you wouldn't be here. Discomplicate, uncomplicate. Number one. Two, and explain it to me in a way that I understand. And I tell them, if you read the report or you hear the testimony, either way, because the expert's there to uncomplicate and help you understand. If you don't understand things, the expert's not doing her job. Either she doesn't care or she doesn't know what her job is, which is to uncomplicate. And using jargon is not uncomplicating. It's frustrating. Or using concepts that non-experts don't understand. Is not uncomplicated and it's not making it understandable. So that the audience, the reader of the report or the testimony, person listening to your testimony, so they can come to their own judgments about the adequacy of your database. Whenever possible, I'd say when we're writing reports or when we're testifying, we tie the data or what we assert as data to the source. So I'll say, the defendant told me he graduated high school, or I'll write the defendant reported graduating high school versus review of documents provided by the defendant included, among other things, a 1986 diploma from Santa Fe High School, right? I might say the defendant reported that he enlisted in the Marines obtained the rank of E5 with no sanctions or discipline during his 5 years, contrasting that to the DD-14 that was provided for review. And I would explain that the DD-14 is a summary of the person's military service, just in case people didn't know what that was. The DD-14 reflects that the defendant served for a total of 5 years in the U.S. Marine Corps. He had attained the rank of E5 at the time that he concluded his term of service, and he was discharged under honorable conditions. Or it might include something different, something different. Not only do we include the data that support our opinions, but we include the data that are inconsistent with or could be used to challenge our opinions. That's because this is about the truth, the whole truth, and nothing but the truth and the whole truth. And initial responses to this direction might be, but wait a minute. If I include data that are inconsistent with my opinions or could be used to challenge my opinions, all I'm doing is providing ammunition for cross-examination. Yeah, it's exactly right. Because if you're really, really embracing the role of the expert, what you're trying to do is be helpful to everyone, the court, the judge, maybe the attorney who hired you, and the attorney who didn't hire you. You're trying to be helpful in terms of them understanding this complicated stuff, this person's emotional, behavioral, and cognitive functioning as it affects her ability to understand and participate in the legal process. And that means that if there are weaknesses in our opinions, limitations to our opinions, caveats, we want everyone to know that if we're really embracing the role. Now, if the goal is to just do the evaluation and provide no indications of mistakes we made or weaknesses in opinions, well then sure, just provide the data that supports your opinion and makes you look good. But I think that's in conflict with what is expected of the expert. If we're missing important data or data that's normally relied upon, we affirmatively disclose that. You're carrying out a competence evaluation and you were not able to access any documents that provide an independent description of the allegations, right? What the defendant's accused of doing that forms the basis for the charges. We note that my evaluation was hampered by the fact that the only information I had about what the specific allegations were relayed to me by the defendant. Typically, I'm provided with an arrest report or something similar that gives me an independent look at what the defendant might have done, independent from his or her own representation. I didn't have that here. It would be a better evaluation if I had it. Now, you might go on to explain why you don't have it, describe the effort you made to get it, but we affirmatively disclose when we're missing important data. Talked about this last week. Only expert opinions are offered, okay, or as much as possible. Again, I'm not gonna stay up at night if you write that the defendant arrived promptly. I think I made the point last week. That's not an expert opinion. Your expertise is not in timing, nor is mine. But try to keep the opinions to expert opinions. That's why we're there anyway. So opinions we offer should be based on specialized knowledge that we have, that the lawyers and judges don't. And then when we provide opinions in our reports and our testimony, we make an effort to provide the factual bases. What are the facts underlying the opinion and the reasoning? This fact and this fact and this fact go together to lead me at least to opine that the defendant's ability to work with counsel is limited. Once you, as the reader of the report, read that, well, Otto says it was three facts that led him to opine that the defendant's ability to communicate with counsel is limited. You can decide for yourself, as the reader of the report, whether you are willing to form the opinion of limited ability to consult with counsel based on those three facts that I provided. And hopefully, when I form opinions, I offer an adequate factual basis. And by that, through that, I end up persuading you to adopt my opinion, among other things. One of the opinions being this defendant's ability to communicate with his lawyer is limited because, after all, he couldn't do these three things or had difficulty manifesting those abilities or whatever else. And like I said, not only the facts and the opinions, but the reasoning underlying it. Anthony, earlier today, I'm not sure if it was before or after the lunch break. I think it was before the lunch break. He was talking about, well, what if there's two cases, two independent cases, and you're doing competence, and they joined the cases, and you're offering an opinion about the defendant's competence to move forward with both sets of charges, and you spend a fair amount of time talking to the defendant about the first set of charges, and he is disjointed and tangential and circumstantial and confused and providing irrelevant responses to most of your questions. And you don't even get to the second case, he said, right? So you might, in case with respect to addressing the second case, which you really didn't talk to him about at all, you could maybe offer an opinion like Anthony was suggesting. Not only do I believe the defendant is incompetent to move forward with the first case, but the second case as well. And this is my reasoning, because the deficits that he displayed when we were discussing the first case, I have no reason to believe that they would not be present if and when I got a chance to talk to him about the second case. That's my reasoning. That's why I'm offering an opinion about his competence in a matter that I really didn't even get to address with him at all, because he terminated the evaluation early or whatever. Should experts, after they write their report, confer with attorneys? Well, if you're working for the attorney, confer away. If you're working for the attorney, confer away. That's one of the reasons she hired you. Okay, so no problem there. I think we get a little anxious and nervous when we're not working for an attorney and one of the attorneys expresses an interest in talking with us, particularly after we submitted the report to the court. I don't think there's any specific prohibitions against it, but what I would do is, when I get such an invitation in a court-appointed context, is I always want at least an invitation to go out to the other attorney. I'm not going to make you depose me. I have no problems answering some of your questions if you don't want to depose me. But what I don't want is, I don't want accusations of ex parte communications. I don't want any kinds of accusations that I've provided. I've been more helpful to one side than the other. So sure, Mr. Prosecutor, I'm happy to talk to you about the report I wrote in anticipation of this hearing. If you don't want to depose me and it's only going to be 15 minutes, that's fine. But let's at least invite the defense attorney in on this discussion. So that's my take. That's my take there. Subpoenas and depositions. Subpoenas are issued by attorneys. The expert must respond to subpoenas. and participate and answer questions uh, that are presented by subpoenas, which are typically for depositions, unless there's some kind of exception. For example, a subpoena for records when the records are attorney-client privileged, or maybe therapist-client privileged, or if maybe there's claims that the information's irrelevant. But what we can't do is we can't ignore subpoenas, right? We can't simply ignore subpoenas. We have to respond, and maybe the subpoena's for records. Maybe the subpoena is for a deposition, and that's subpoenas. Depositions. Depositions, what do they involve? Sworn testimony, right? Before you start talking, you take an oath to tell the truth, the whole truth, and nothing but the truth. Your testimony is memorialized. You typically must answer all questions, even when there's objections. That's really interesting, right? Because most depositions, there's two attorneys and the deponent, the person being deposed. What there is not is a judge, but yet there's still objections. So the objections are not ruled on, and the objections are for the record. So maybe you write your report, you carry out your evaluation, there's a deposition request. It's going to be from one attorney. I assume the other attorney will be there. Question may be presented, there may be an objection, you still answer the question. In court, they ask you a question, there's an objection, you don't necessarily testify, depending on how the judge treats the objection, sustains it or overrules it, in which case you do answer the question. Depositions are part of the discovery process, right? Where both parties are trying to discover things. I think in a competence context, it would be you wrote a report and the parties are trying to discover some details about the evaluation that are not obvious from the report. Deposition transcripts can't be used as evidence unless the witness is unavailable at the hearing or trial. So depositions aren't used for purposes of production of evidence, but rather depositions are used for the purpose of discovering some more things that are not, presumably in most of these contexts that we're talking about, things that aren't apparent based on the report you wrote. Depositions, however, can be used to impeach testimony at a hearing or a trial. So if you're deposed prior to a hearing, and that allows the attorney with some confidence to predict what you're going to say at the hearing. If you say something different at the hearing, the attorney can reference the deposition and present you with what he or she believes is the inconsistency. Dr. Perillo, do you remember a month ago you were deposed in anticipation of this hearing? Yes, I do. Do you remember when I asked you a little bit about your diagnosis of the defendant? Yes, I did. And do you know what the diagnosis was? Do you remember the diagnosis you provided me a month ago? No, I don't. Would it refresh your recollection if I provide you a copy of the deposition where you can read what was recorded? Dr. Perillo says yes. Oh, yes. Now I remember I said schizoaffective disorder. But yet, doctor, today you come here and offer your diagnosis as schizophrenia. Help me understand that inconsistency. Okay. Used to impeach, which is just sort of challenge, that means nothing more really than challenge, which means anytime you're deposed, at the very end, they're going to say, well, doctor, do you want to read or waive? And the answer is, oh, I want to read. I want the opportunity to review that memorialized transcript so I can correct any errors I made and any errors that the court reporter made. Let's talk about differences between testifying in depositions and hearings or trials, and similarities. In both cases, The testimony is sworn. You swear to tell the truth under penalty of perjury, and it's memorialized. Court reporters there typing down everything you're asked and every answer you provide. You might not need a deposition if a report's been written, because they pretty much have a good idea of what you did and what your opinions are and what your reasoning is. Similarly, you might not have to testify at the competence hearing if it's a good report, if it does everything that it should do. So you can avoid that. Depositions, the defense and the prosecutor are present. Hearings or trials, the defense, the prosecutor, and the judge are present. And in non-competence matters, you could even have a jury. As I said earlier, objections are lodged, but there's no ruling because there's no judge in a deposition. Those objections are for the record, consideration at a later time. Objections are lodged and ruled on. Regardless, when you're testifying in a deposition or a hearing or trial, you always take pause after the question's presented to give the other attorney a chance to object. It doesn't need to be a long pause, just a pause, so the objection can be lodged if there is one. What's the purpose of the deposition? It's part of the discovery process. Get the expert to commit to opinions so you can predict what she will say at trial. Find out a little bit about the expert. Find out a little bit about the expert. Ask her questions about her background and what she did that wasn't apparent from maybe a report. Discover what the expert did or did not do and concluded. And also discover how good a witness the expert is and will be. Now, some of this, again, you need not do this if it's a great report. You know exactly what the expert did. You know exactly what opinion she formed. You know exactly what her reasoning is and the underlying facts because she wrote a great report. You don't know what kind of expert she's going to present as when she testifies. You don't know that based on the report. You can figure, well, if she did a great job here, maybe she's a good witness, but maybe not. Does this witness come across as arrogant and entitled? Or does this witness come across as convincing and modest and highly qualified? That might have implications for what you as the attorney are going to do next. At a trial or hearing where someone's trying to persuade the fact finder, direct examination carried out by the attorney who's happy with the expert's opinion. Direct examination is designed to communicate to the fact finder just how expert this witness is, just how sound this expert's reasoning and techniques are, and just how much this expert's opinions should be adopted just because she did such a good job. The goal of cross-examination is to raise questions about any aspect of the expert's technique, the expert's reasoning, the expert's database, so as to decrease the likelihood that the fact finder will be persuaded by the expert. Deposition is almost always initiated by the attorney who did not retain the expert, or if the attorney's court appointed, court retained, it's going to be the attorney who really is not happy with the expert's opinions. The expert's appearance in court is initiated by the attorney who's satisfied and happy with the expert's opinions, the expert's work, the expert's reasoning. The other attorney would hope that the expert be hit by a bus and die and not appear at the hearing. That would be that attorney's preference, because they don't really want the expert's opinions, who they don't support, doesn't support their legal argument. They don't want those opinions being adopted by the legal decision maker. Deposition, you'll be questioned by one attorney, maybe two. The attorney who didn't subpoena you for the deposition has the right to ask you questions, is under no obligation to, and whether the second attorney does question you, will is largely a strategy matter. If that attorney thinks that there were some issues that you got confused about during the examination by attorney one, the attorney might ask some questions to sort of deconfuse you so you can maybe offer better responses. Or the second attorney might think, boy, you did a great job. I don't need to waste time asking questions. I don't need to show any of my hand by asking questions. I don't think I've ever been in a hearing or trial and not been questioned by both attorneys. I don't think I've ever been at a hearing or trial and not been questioned by both sides. One attorney, pretty happy with my opinions. The second attorney, less happy with my opinions. Attorney number one is conducting direct examination. Attorney number two, cross-examination. What about testifying? What about various kinds of issues? How does one dress? I recommend mimicking attorneys' styles. Pretty easy to get a handle on what's considered appropriate in a particular jurisdiction. I remember I had a summer placement in Hawaii, and I was shocked at cultural differences in dress in some kinds of settings. So I remember once I saw an FBI agent in Honolulu testify in a Hawaiian shirt, testified in a Hawaiian shirt. But I think that's Hawaii. I don't think that's Albuquerque, although I've yet to testify in an Albuquerque hearing or trial. But maybe look to how attorneys dress. Whenever possible, respond directly. I'm sorry. Whenever possible, direct your responses to questions to the decision maker. After all, that's the person you're trying to persuade. You're not trying to persuade the attorney who's asking the questions, trying to persuade the decision maker. So you want to make sure they hear your response to the question. Sometimes it's hard to direct your response to the decision maker when the decision maker is the judge, for example, because maybe you're sitting on the witness stand and it really doesn't give you direct access, a line of sight to the judge. I mean, you just have to deal with that. You can't be turning around every 2 seconds and directing your response to the judge. That's going to get old real quick. If you can, adopt a conversational tone. Lay language and explanation of jargon. Here's an example of how testifying is, in principles, very similar to report writing. Be courteous with attorneys. Now, I don't think Anthony ever considered being a lawyer, but he's not a lawyer, but he's going to play one a little later this afternoon. And he's going to have to conduct a cross-examination of me. And sometimes attorneys carry out cross-examinations where they're completely appropriate and well-behaved and respectful and all of that. Sometimes attorneys conduct cross-examinations where they're mean and they're nasty. We'll see just how nasty and mean Anthony can be when he's carrying out cross-examination. But the point is, and I do have one, the point is even when attorneys are discourteous to us, we should be courteous to them. Because I think in most cases, that sort of discourteousness is intentional and planned. And I think what they're trying to do is they're trying to trigger us to get down in the mud. And I don't think you or I do any kind of service to ourselves if we get down in the mud. I can be just as rude as that nasty cross-examining attorney. I think if there's a nasty, rude cross-examining attorney and you can maintain your composure, easier said than done. You can maintain your composure. It can actually work to your benefit, right? In that you might come across as sympathetic. At a minimum, you won't come across as rude. So I always suggest to people without a lot of experience testifying is also keep in mind that if an attorney does get rude and discourteous, that might be all they have, right? That might be all they have. So if that's all they have, you know you're in the home stretch. Apparently, there were no reasonable challenges to who you are, your technique, your reasoning, and your opinions. Can't make a big deal out of substance. So what do you go for? Well, let's get Dr. Otto to lose his patience or lose his temper, come across as arrogant and entitled. Who do you think you are? I've been doing this for 35 years. Something like that, then maybe, just maybe, the decision maker will discount all of the points I made and how persuasive I was when I was talking about my effective technique and all of that. So again, easier said than done in terms of maintaining composure when people are either making inferences that are not particularly um, not particularly complimentary, or maybe not, maybe just out and out asserting things, not even inferring, but asserting them, calling you confused or illogical or not making sense. That's a little more direct. Don't take the invitation, you know. Speak with confidence and appear confident, but avoid the patronizing air or absolute certainty. So there's this sort of there's this challenge of coming across as confident, don't want to appear lacking confidence, but at the same time, not coming across as arrogant. Okay, like you think you're the smartest gal in the room or something like that. Simply answer the question. Don't volunteer information. If you're in the hearing or trial, if there is an objection, well, act like you've been there before. Don't respond. Allow the objection to be treated by the judge, and then there'll be direction as to what you do, which is either, hey, witness, answer the question, or attorney, come up with another question or find a better way of asking that. Um, Years ago, I went to a workshop given by a trial attorney on expert testimony, but it was a trial attorney who was providing the workshop. And she said one of her pet peeves was witnesses, particularly experts, who don't simply answer the question. And she said, for example, if I ask the expert, doctor, after evaluating the defendant, did you come to a diagnosis? She said, there's two answers that are acceptable. Yes or no. There's no other answers that are acceptable. There's no, for example, she said, paranoid schizophrenia is the wrong answer. It's yes or no. Her point was, I might have a reason not to share that information right now. Just listen carefully and just answer the question. Also, there may be some times where the right answer is, I don't know. Okay. And I think we should always not acknowledge that it actually can be beneficial in some ways. A colleague of mine once said that by willing to answer, I don't know, or I don't know that, you can actually communicate indirectly to the decision maker, I know what I know, and I know what I don't know. And I'm willing to identify those things that I don't know, but if I do know, I will tell you. That's all unsaid, right? But you can actually increase the decision maker's confidence in the opinions you do offer by acknowledging that you don't have opinions about everything and you don't know everything. The direct examination process, it's going to be typically on starting out with your qualifications. We talked about this a little last week. Who's an expert? What makes for an expert? I think it's typically can be sort of distributed across three categories. One is education, two is experience, and three is the often ignored category of evaluation procedure. But whenever I talk to attorneys, I tell them when you're trying to qualify the expert during direct, not only talk about education, not only talk about experience, but also talk about evaluation procedure, affirmatively trying to establish that the evaluation procedure was a sound one, and one that would provide data that are important to forming the relevant opinions or psycholegal opinions. A few things here. I recommend that experts be very brief in this section. Um, uh, we're not going to do a sample qualification because the reality is in many court-appointed cases in the competence arena, you're not going to be subjected to a very intense or involved qualification because after all, the judge appointed you to do the evaluation. It's going to be very awkward for a judge to appoint you to do an evaluation where there's a presumption that you're qualified to do the evaluation. It's going to be very awkward for an attorney to come in and challenge your qualifications in the case of court appointment because it's going to put the judge in a very awkward position. Well, I appointed the good doctor here to do the evaluation, but apparently he's not as knowledgeable or skilled or competent as I thought. So I'm going to preclude him from testifying, or that'll just go to the weight of his testimony. I don't think you're going to see a lot of that. But I've yet to be in a New Mexico courtroom. I can tell you, in my experience in other jurisdictions, court-appointed experts not getting a lot of attention in the qualification arena. So if they are asking the questions, get through them as quick as possible. Dr. Otto, could you tell the court a little bit about your education? Yeah, I was awarded a bachelor's degree in psychology from the University of Rochester in 1981. I immediately enrolled at Florida State University. I obtained a master's degree in clinical psychology in 1985, a doctoral degree in clinical psychology in 1987. Then did my one-year internship at the Medical University of South Carolina. Then I did a 2-year fellowship in the psychology department in the College of Law at the University of Nebraska. Boom. I think I knocked that out in less than a minute. Right? I'm not going to go into great detail about the education. Right? Tell us a little bit about your relevant experience. I'm going to be very selective as to what I talk about, right? I'm not going to talk about all my experience that is wholly irrelevant to what we're here to talk about today. I'll talk about my experience in my supplemental training that's relevant to evaluating criminal defendants and evaluating defendants' competence to proceed with the process. I'll talk about how often I've done that, where I've done that, how many times I've done that. And then I'll talk about the technique, but I don't want to clutter their minds with the minimally relevant stuff. So that's, typically what you're going to get. Keep a record of all your sworn testimony. That includes depositions and affidavits. It's required in some jurisdictions, including in New Mexico. I have done a few cases here in New Mexico where they have asked for that list of sworn testimony. And again, it doesn't have to be in a hearing or a trial. It could also be in a deposition. So you want to keep a record of that because you wouldn't want that. Last thing you want is for someone to demand a list of all the cases you've testified in the past 15 years, and you don't have that list. And now, well, it wouldn't be the past 15 years, maybe the past 5 years. And now you're trying to reconstruct that list. That's going to be a nightmare. Okay. Direct examination. There's all different kinds of ways that this can be done. They can start out with, doctor, did you examine the defendant in this case, my client? Yes, you did. For what purpose? To assess his competence to stand trial. Do you have an opinion as to whether he's competent to stand trial? Right out of the gate, ultimate issue opinion. You think he's competent or not once they establish what you did and why you're there. Okay. Or they could do it at a very different approach. Did you evaluate my client? What did that evaluation involve? What kinds of data were you provided? What kinds of data did you collect? And then it could be, could you highlight some of the most important things about what you learned about my client? Okay, now that we know that, let's talk a little bit about his understanding of the legal process and his ability to work with counsel, right? And then they don't ask you until the very end. Do you have an opinion or recommendation as to his competence to stand trial? Yes, I do. And what is that? So they can play this in a bunch of different ways. So I'm talking here, they might use what some have called a pyramid approach. Now, let's first talk about the evaluation procedure. You administer tests. What's the purpose of those tests? What data did you collect that's important? What opinions did you form? Sub-opinions. Does he have a mental illness? Is he able to work with his attorney, understand, comprehends the reasons for punishment, whatever else, and then ultimately get to that. Or they could come right out of the gate with that and then sort of go through this pyramid approach. Direct examination obviously is always easier than cross-examination. I equate direct examination to playing softball. Big ball, thrown slowly, easy to hit. In fact, you don't have to be particularly skilled to hit the softball a long distance, okay? I equate cross-examination to baseball, hardball, right? Pitcher throws a curve, a slider, a changeup. Much more difficult to anticipate what's coming at you and much more difficult to hit and do well. Much harder to hit a baseball a long way than a softball. A baseball thrown by a good pitcher at least, okay? You'll be much more relaxed during direct examination. You're going to get open-ended questions that will allow you to pontificate and go on and on. You're much more likely to get focused and direct questions on cross-examination, including a lot of yes/no questions, because the attorney is trying to keep you pinned in. The attorney's trying to keep you pinned in. You'll often hear that one of the cardinal rules of cross-examination is never ask a question to which you do not know how the expert will respond. Never ask a question that's truly, I'd like to know, but only ask a question that will give you a response that you anticipate. And if you can't anticipate a response, maybe don't ask the question. Because what the cross-examining attorney is trying to do is make an argument with your responses to questions, okay? And wants to keep you hemmed in in terms of being very predictable in terms of what your answers are going to be, and be selective in the questions that he or she asks accordingly. So you get a lot of yes, no, a lot of yes, no questions. Doctor, isn't it true that? Isn't it true that? And that sort of suggests a yes, no. My response is, whenever you're asked a yes, no question, answer it yes or no when you can. Whenever you're asked a yes, no question, answer it yes or no when you can, particularly during cross-examination. If if you think a yes, no question is really a problem, you might show a little more resistance. Okay. You could say, I don't think I can answer that question, yes or no. You could say, I think a yes or no answer would be potentially misleading. Uh, you could maybe use a strategy like an admit deny technique that we have listed here. Although, doctor, isn't it true that psychiatric diagnosis has real problems with reliability, inter-rater reliability specifically? You don't want to necessarily say yes to that. You might say, although uh, there are certainly problems with examiners being consistent in the diagnosis they give people uh, that they assess, even when they assess the same person. In this case, the reliability and validity of my diagnosis, I'm not particularly concerned about, because I have all these data sources, or this is the steps I took to come up with a diagnosis for Mr. Jackson, or whatever else. So sort of give them the yes up front with the admit. It's a dependent clause, although there have been demonstrated problems with reliability of diagnosis in this case. And then you go on to sort of give them the, well, I'm not going to give you what you want. Sometimes there'll be questions about the unreliability of your facts, or maybe the invalidity of your facts. You got to deal with it like you deal with it. You might say, well, you're certainly right. I acknowledge that criminal defendants sometimes have motivations to not be wholly forthcoming. I'll acknowledge that I did at times rely on what the defendant did tell me, although I do acknowledge that sometimes defendants might not be fully forthcoming, or be wholly candid in their responses. That's why, in addition to speaking with the defendant, I reviewed records of prior treatment. I reviewed the arrest report that provided an independent accounting of what the defendant did at and around the time of the alleged offense. So that might be a way to respond to that. Would it surprise you to learn that? Would it surprise you to learn that? Your answer might be yes. I'd be very surprised by that. Now, you might get hit with on return. Well, that suggests that he's going to come across and say, well, here, now I have evidence to that effect. Sometimes they'll give you inaccurate data. So they misrepresent what is said. So for example, once I was evaluating a defendant who was charged with capital sexual battery, terrible case. He was accused of kidnapping a 6-month-old child, sexually abusing the child, and then leaving the child out in the woods at night. Thank God they found the child, and the child lived. And it was a competence to stand trial case. And this defendant that I examined, he didn't know anything. Right? He didn't know what guilty meant. He didn't know what not guilty meant. He didn't know what a trial was. He didn't know what this guy who got to 11th grade, he didn't know any of this. So throughout my report, I wrote things like, Mr. Jackson reported that he didn't know the meanings of the terms guilty and not guilty. Mr. Jackson reported that he didn't know what a judge was or what a jury was or what a trial entailed. Mr. Jackson stated he didn't know what a prison was. On cross-examination, I'm getting this. Well, Dr. Otto, you've already testified that my client doesn't know what guilty and not guilty means. I said, no. We can have the court reporter read my testimony, but I'm very confident that I testified that Mr. Jackson said he didn't know what guilty meant or what not guilty meant. He said he didn't know what a judge was. He said that he didn't know what a prison was. As you know from my report and the rest of my testimony, I have very good reason to believe that that's not an accurate representation of what he actually knows. So I believe the evidence shows not what you're alleging or not what you're suggesting here, but something very different. I told you earlier about cross-examination might entail an attempt to anger you. And I think that if you maintain your composure, you can make the attorney look like a bully. You might even come off as sympathetic. But most importantly, I think what you take is if the attorney is really making a concerted effort to make you angry, he's all out of, he only does it because that's all there is left, right? That's all there is left. They might suggest, oh, I don't think they're going to suggest your testimony is bought when you do these evaluations by way of court appointment. How much are you being paid for? How much are you being paid? How much are they paying you for your testimony today? That's one way to suggest that. But you were appointed by the court. So it's not as if you're getting direct money directly from the attorney who called you to testify by way of direct examination. They might try to suggest that you're much more likely to come up with opinions that are more supportive of opposing counsel. Like if it's a prosecutor, isn't it true that, most of the time you see defendants as incompetent rather than competent? Or if you're not doing these evaluations for the court, you're doing them for the public defender's office. If you are getting paid a lot of money, and I don't think you would say that the rate of compensation for these evaluations is a lot of money. I would say it's not a pittance, but it's not a lot of money. Keep in mind that jurors, at least, are affected by amounts of money that experts are paid. And if there is a meaningful discrepancy between what expert A gets paid and what expert B gets paid, it can affect jurors' assessment of the expert's independence. Some research done in that arena. I don't think this is going to happen, but they might try to impeach you by way of a learned treatise. This is really sort of more complicated stuff. If they can get you to recognize a written product, a book, an article as authoritative, then they can use what's in that written product, what's written, to challenge opinions you offer. So if they could get you to say, Dr. Perillo, would you agree that the DSM-5 is authoritative when it comes to psychiatric diagnosis? Dr. Perillo says, yes, I consider the DSM-5 authoritative. Then, literally, the lawyer can pick up the DSM-5 and use excerpts in the DSM-5 to challenge what Dr. Perillo testified to. Dr. Perillo, you previously testified that schizophrenia was characterized by X, Y, and Z. And you said the defendant in this case demonstrates those symptoms. You previously recognized that DSM-5 is authoritative. I'd like to present this page here of DSM-5 for you to read. And I'd like you to read it aloud, actually. And start here where it says schizophrenia is characterized by. I guarantee you, whatever's in the DSM is not what Dr. Perillo just testified to. Dr. Perillo said this is what schizophrenia is. The DSM, which he recognizes authoritative, says this is what schizophrenia is, and it's different. So I'm going to use that to challenge some of Dr. Perillo's testimony. Now, you might say, well, I'm just going to say that I don't recognize it as authoritative. I don't think the DSM-5 is authoritative when it comes to diagnosis. I think the attorney's response is going to be, did you use the DSM-5 to come up with a diagnosis of this defendant? You're probably going to say yes, maybe not. You're probably going to say yes. And then I think the attorney's going to say, Judge, maybe, just maybe you want to rule that indirectly Dr. Perillo has recognized the DSM as authoritative. After all, he used it. Okay, so think about that. You could recognize it as authoritative and say you don't agree with everything that's in it. If they quote part of their learned treatise, you're allowed to take the treatise and look at it in context, et cetera, et cetera. I've been doing this for 36 years. Only once in my career has an attorney attempted to impeach my testimony by way of a learned treatise, and that's nothing special about me. I think most people with experience will tell you that it's a very uncommon strategy. They might present you with a hypothetical question. Doctor, imagine a case where, and this is a hypothetical case, of course. Now, this hypothetical case is going to be very similar to the one that we're talking about in court today, but it's a hypothetical case. And they're going to try to get you to form an opinion about this hypothetical case that looks very much like the case that's in front of the judge here in the courtroom today. And they're going to try to get you to an opinion that's inconsistent with an opinion that you offered in this case. You see, here, as a general rule, hypothetical questions must be based on facts and evidence, or upon evidence which the propounding attorney assures the court will be admitted into evidence. So the hypothetical question has to bear a lot of similarities with the case at hand, okay? But a hypothetical question, the court can decide on its appropriateness. I think in my career, I faced less than 5 hypothetical questions. Again, very uncommon cross-examination strategy. So with that sort of brief overview, any questions about writing reports or testifying in principle? Anything?
We did have one brief conversation in the chat about how would you handle an attorney who's not calling you doctor, but Ms., Mr., etc.
Well, so there's I have a few thoughts. Thank you for the question. I have a few thoughts. First of all, I think I'm going to tell you what I do, but then I'm going to get a little more complicated. I don't correct them. You call me Randy if you want. I don't care. I don't want to be invested in that. I'm not invested in that. And I don't want to, unless I'm trying to get into first class on a plane. But otherwise, I'm not invested in that. And I don't want to come across as that's really important to me. My name's Doctor. Don't you know don't you know that I went to school? I don't want to come across that. Now, that's me. That's me. You might have another take on this. And I'm also going to acknowledge that I think this is different for women, because I think there is, I've been told and I've observed sexism in the courtroom. So obviously, as a non-woman, I don't have to deal with any of that stuff, right? And I think women, I've been told, I haven't seen this, but I've been told, are more likely to get this indirect or maybe direct attempts to minimize and disparage. But I'm not going to play into it, given who I am and where I've been and what I've done. I'm not going to criticize anyone who does, but I want you to think about it. And I am sympathetic to people who, classes of people who do get disparaged more than I get disparaged as an old white guy who has a white beard and doesn't have much of his hair. So I don't make attempts to correct them. I think it's much more powerful when someone other than me does it anyway. But I'm not going to criticize anyone. I was once went to a workshop, expert testimony workshop, and one of the speakers was a forensic psychologist from Michigan, and she did mostly criminal stuff, and she was saying how she was testifying once. This issue was brought up. She was testifying once, and quite quickly during cross examination, it went from uh, uh, Dr. Jackson to Ms. Jackson, right? So that kind of thing. And she said, and I didn't even take the bait. Said, I didn't take the bait. And then uh, the judge said, Mr. Cross Examiner, I suggest that you refer to our witness as Dr. Jackson. She's a, what, so the judge did it. But then later he gets back to Ms. Jackson. He gets the direction from the judge. It's Dr. Jackson. Gets back to Miss Jackson. And he says, "Oh, I'm sorry. I'm sorry. Please accept my apologies for again referring to you as Ms. Jackson. You understand, don't you?" And she said, "You can call me Carol for all I care. My job is to come here and offer testimony about the defendant that I examined in this manner. If you can't keep that straight, that's okay. But let's just move forward." And she really that got a laugh, by the way, from she said much of the courtroom. Which leads me to my last point, which is be very, very judicious in your attempt to be humorous when you're on the witness stand. Um, one of my rules of expert testimony is none of us are as funny as we think we are. Okay. So if you try to be funny and you're not, and people don't get it, or worse, you get a reaction like, well, Dr. Otto, I appreciate the effort at a joke. You'll understand if I don't laugh. My client is looking at spending the rest of his life in prison, so it's hard to find any of this funny. What do you do to that? No, didn't you get the joke? What do you just walk away with your tail between your legs. So really, really, really resist the effort to be funny. If you have to be funny, you feel like you have to be funny, maybe try to be funny at your own expense. But let's not, she pulled it off. She pulled it off. But I'm very cautious. Any other questions, Anthony? Otherwise, we'll get to our brief, direct and indirect mock here. So what we're going to do is I'm going to tell you about a case I had. We're going to use names, but all of these names have been changed to protect the guilty. The defendant is Kevin Harness. That's what we'll call him, Mr. Harness, 19 years old, mental health history since the age of 15. Right when he's 15, it's a lot of externalizing, aggressive, oppositional behaviors. And now he's 19. So 4-year history of contact with mental health professionals because of externalizing kinds of behaviors, but more recently he's had psychiatric hospital admissions in response to grandiose and paranoid delusions. I've got a bunch of wives and girlfriends. They've been kidnapped by cartels. I have all these women. They all love me. Auditory and visual hallucinations, along with symptoms of mood disorder. And so behavioral conduct problems during his mid-teenage years, translating into what diagnoses that have been offered, including major depression with psychotic features, dysregulated mood disorder, schizoaffective disorder, uh, major depression with psychotic features, along with a very regular pattern of cannabis use, daily use. He's 19 now. He's got 4 charges: breaking and entering, and resisting, evading, or obstructing an officer. He's accused of breaking into a vacant house. The police come. He tries to run off. They tackle him. That's case 1. He's in jail for about 5 days, and he's accused of assaulting, battering a deputy, aggravated battery on a peace officer, and battery on a peace officer. So 2 cases, 4 charges: 2 in the community, breaking and entering, resisting or obstructing an officer, and then aggravated battery and battery for what he did to what he's accused of doing with jail deputy. Public defender requests evaluation because compromised ability to answer open-ended questions, limited insight into his illness, confused thinking, impaired memory, difficulty remembering information she provided him about his case, impaired orientation, and he's been treated for mental health problems in the past. I wonder whether he's competent. So that's the defendant, that's the case. Anthony is going to be accommodating public defender who requested the evaluation, who will conduct direct examination. We'll try to make some points here, and then we'll stop that at some point, talk about what we saw, and then he'll become more assertive state attorney who's thinking that maybe my opinion that the defendant is incompetent is maybe not so well founded. So we have about 45 minutes. That's plenty of time, by the way, when you're doing something like this. It gets boring after a while. Anthony, I'm just going to ask you to keep an eye on the clock in terms of the questions you're asking, because you're pretty much in control. I'm not.
Certainly.
We're not going to qualify me, gang, right? Because it's pretty perfunctory in this kind of a case. All right. Can
Good
we,
afternoon.
is there a way for us to pin ourselves, Anthony, or is that what they call it? We pin ourselves, so the two.
I don't know if you can pin 2 people.
Oh, okay. Well, then let's just
I-
keep it like this.
What
Hopefully,
people can do is, I mean, they can go to the meeting rather than share screen, or we could just exit the share screen and people can set it up
yeah.
to highlight the
So
person
I
that's
stopped
talking.
sharing screen. I
Okay.
stopped sharing screen. Okay.
Okay. It looks like it started again,
What
actually.
started?
I can see your PowerPoint
What? I
application.
can't.
Oh,
Okay. Here we go.
there we
How
go.
about now?
All
Okay.
right.
All
Yeah.
right.
Yeah. And if people want to, they can look at the speaker rather than the gallery view.
Probably minimize the chat too.
Yeah. Yeah. All right.
All right.
Good afternoon, Dr. Otto.
Good afternoon.
Did you examine Mr. Harness in response to order of the court?
I did.
For what purpose?
It was to assess his competence to stand trial.
And are you contracted by the state of New Mexico to provide these exams?
I am. Yes, it was done under that contract.
What did your examination entail?
It was a little over 3 hours. It was done face to face. Many of these evaluations now are done by way of video conferencing, but it was done face to face. He was transported to my university office. Before I even met Mr. Harness, I had a fair amount of information, including the referral form that you completed to facilitate the examination, your motion to the court, where you requested this examination and provided your rationale, which largely redundant with what you included in the prior document. I had the arrest report. I had the charging documents. I had records of his treatment at one of the mental health, inpatient mental health facilities where he's been treated. I had the jail medical records as well. I had two reports that had been conducted by psychologists, neither of which were focused on competence, but were evaluations more done to facilitate treatment. I interviewed his father as well for a little under an hour, and that was remotely by way of a phone call. I ended up interviewing Mr. Harness for about a little less than 2.5 hours, and I used three different tests or tools: the Beck Depression Inventory, the Fitness Interview Test, and the HCR 20.
So you used several different sources of information during your examination. Is that correct?
Certainly.
Yeah. I want to ask you some focused questions here. Dr. Otto, did you find that Mr. Harness suffers from a mental disorder?
Yes, I did.
What is that mental disorder?
I offered two diagnoses. The diagnoses I offered included schizoaffective disorder. That's an illness that's characterized by impairments in someone's mood, how they feel. Uh, it's also characterized by impairments in both how they think and what they think, impairments in thinking and impairments in mood. And the reason that I came up with that diagnosis is because, by way of the testing that I administered, by way of the records that I reviewed, and in my focused interview with Mr. Harness, became apparent to me that he experienced meaningful symptoms of depression that lasted for extended periods of time. Symptoms like feelings of worthlessness, failure, and guilt, a lack of self-confidence, difficulty making decisions, subjective feelings of sadness, pessimistic thinking, increased irritability, increased need for sleep, and diminished energy. All of those can be symptoms of depression, and he experienced them for extended periods of time in a significant way. But along with that, there were impairments in how he thought, how he thinks, and what he thinks. Specifically, he has some delusions, which are fixed, false beliefs. Fixed, they don't go away. False, they're inaccurate. These include things like he has many girlfriends and wives that have been kidnapped by cartels who are angry with him and want to hurt him and harm him. He has really little insight into the fact that these are delusional beliefs. This is not reflecting reality. He has impaired judgment in that way, and that he doesn't think that he really needs treatment other than for maybe some of these symptoms of depression. He also reported to me experiencing both visual and auditory hallucinations. That is, seeing things that aren't there. He reported seeing the devil, um, uh, uh, as an example, and hearing things. He reported hearing people talking to him when no one was talking to him. So that combination of symptoms of depression, along with the symptoms suggesting impaired thinking, led me to come up with the diagnosis of schizoaffective disorder. And I also provided a second diagnosis of cannabis use disorder because of prior to his current incarceration, what he reported is a 4-year history of daily marijuana use that has impaired his functioning and ability to get along with people in a variety of different ways. So two diagnoses, a mental illness diagnosis and a substance abuse diagnosis.
Going back to that schizoaffective disorder diagnosis that you said Mr. Harness has, what were some of the most notable symptoms of that disorder that he showed you during your examination with him?
A few things. One is that he was somewhat distractible during the examination. So I would ask a question, there'd be a fairly significant latency between when he got the question and when he came up with a response. And sometimes, not always, but sometimes his responses were not very relevant or informative. They weren't very on point. All right. So that was one indicator. I'd also say that, although he was reluctant to get to it and share it, that is, he didn't volunteer this information. But when I asked him specifically about having many wives and girlfriends and these wives and girlfriends being kidnapped, he acknowledged that. Okay, so there was that. So that sort of got me thinking about the impaired thinking, what he was thinking, and difficulties with attention and focusing and concentration. The symptoms of depression were largely reported by him during the interview, including things like feeling guilty, feeling worthless, having difficulty making decisions, being irritable at times, lacking self-confidence, being pessimistic in his outlook, and experiencing subjective symptoms of depression. Not only did he describe himself like that to me, but I told you I administered a number of tests. One of them is called the Beck Depression Inventory. It's the second edition of that test. It's nothing more than a collection of questions that are very symptom focused. And they ask the test taker to report how frequently in the previous 2 weeks he experienced any of these symptoms of depression. Large number of symptoms of depression are covered, and the test taker rates how frequent these various symptoms have been experienced in the preceding 2 weeks. And his score put him in the category of experiencing a moderate level of depression.
Thank you, Dr. Otto. What is your understanding of what factors the court is to consider when making a decision about a defendant's competence?
As I understand it in New Mexico, there's three sort of primary concerns. One is the defendant's understanding of the legal proceedings and whether that understanding and ability to participate in the proceedings is compromised or limited as a function of some kinds of challenges or impairments the defendant's experiencing. The second primary category is the defendant's ability to communicate, collaborate, and work with his attorney, integral to participating as a criminal defendant. And then the third primary category of things, or the third primary content area, is the defendant's understanding of punishment and what that entails, and how that works with respect to his participation in the criminal proceedings.
Let's talk about each of those in succession. What can you tell us about whether Mr. Harness's understanding of the proceedings against him is sufficient?
Well, certainly, Mr. Harness has an understanding of the legal proceedings in the abstract. He was able to recite exactly what he was charged with in both cases. That was a total of 4 charges he accurately recounted, and the underlying allegations. So he has a good understanding of what he's accused of and why he was arrested and what he's charged with. At the same time, I think when it came to that, he expressed some confused thinking about comparing and contrasting the severity of the charges, what charges might be more concerning or come with risks of greater punishments and things like that. So at a very, at a basic level, hey, understood the charges, was able to recite them, recount the underlying allegations, including the dates on which he was arrested and charged. Very good. But there were some concerning areas. Mr. Harness clearly demonstrated understanding of why punishments are imposed, that they're imposed by the government in response to being found responsible for criminal offenses. He understands that as a criminal defendant, he's at risk for being sanctioned accordingly. He was able to provide a general estimate of the kinds of sanctions he could be subjected to that was consistent with my understanding of the sanctions that he was at risk for receiving as a result of these four charges. He offered an adequate description of probation. He described the kinds of things he was required to do in the past when on probation as a juvenile. And he understood he was at risk for imprisonment. And he identified imprisonment as preferable to probation. I'm sorry, he described probation as preferable to imprisonment because he recognized that that would allow him to remain in the community. So I really wasn't concerned about his understanding of punishment as well. Similarly, he offered a well-developed, a basic understanding of the legal process and the roles of those involved. For example, he described you as primarily there to protect him and his interests. All right, so he saw defense counsel as an ally, but he really struggled to identify concrete behaviors that a defense attorney might engage in order to protect the defendant in a legal proceeding, in order to get better outcomes for the defendant than worse outcomes. He understood the role of the prosecutor as an adversary, at least insofar as he stated, quote, the state attorney's job is to find all the evidence against me. Okay, so he understood that, you and the prosecutor were adversaries. He was more limited in how he described the role of the judge, saying that the judge's job was to tell him what he deserved. He was a little confused about bench trials versus jury trials. I spent some time explaining those differences to him. And generally, when he did display ignorance about the legal system and its operation, and I mean ignorance in the true term of the word, lack of knowledge, when I, in response, tried to explain the concepts to him, he did a pretty good job of incorporating that information. As an example, he reported he was unsure of what the jury's job was. I explained it to him. When I talked about it later, he expressed a more developed understanding of the role of counsel. Interestingly, I asked him what he thought would be better if he had a trial. Would he prefer that a judge decide on his responsibility or a jury? He said he wasn't sure, but then he said he'd talk to you about it, but ultimately came up with his initial leaning was maybe a jury trial, because in the case of a jury, the prosecutor's got to convict everyone on the jury. But in the case of a judge, you only got to convict one person. So I thought that was a reasonable approach for his thinking about this when he was presented with an issue that he apparently had never contemplated before. He demonstrated reasonable understanding about a variety of other kinds of legal issues, such as pleas that were available and their significance as well. There were some deficits in understanding, but oftentimes he was responsive to my attempts to uh, educate him about that which he did not know as much about.
Now, what can you tell us about Mr. Harness's present ability to consult with counsel?
That was probably my biggest area of concern here. That Mr. Harness was at an absence to identify the kinds of information that would be important to relay to you. And then even when I sort of educate him about that, he really struggled with the kinds of information that he thought it would be important to present to you. Um, Certainly, I didn't talk about this. I didn't provide any of this information in the report, but I did ask him to talk to me about both sets of charges in detail and sort of to give me his own explanation. Obviously, not in an attempt to affix responsibility or provide that information to the court. And you know as well as I do, I didn't provide any of that information to the court, but really to ascertain how good a job he could do providing you with information that might be relevant to informing your judgments about best courses of action as you represent him. And he fell down there too. So again, when it came to talking about case specific information and identifying what would be important, that was a deficit that I found concerning um, when it came to Mr. assessing Mr. Harness's competence. Relatedly, I spent a fair amount of time talking to Mr. Harness, questioning Mr. Harness about, okay, so let's talk about your case and what you're charged with and what you're accused of. You don't have to make any decisions now, but what do you think the best course of action might be? He was concrete in courses of action that he suggested. And when I asked him to justify why is that a good way to go? Why is that a good legal approach in your case? He gave me logic and rationales that I found very lacking, that they really made no sense and involved expectations that I think are quite unrealistic. And I saw this thinking, his thinking about what might occur, what kinds of case outcomes might occur based on strategies that he preferred as really being tainted or polluted by some of the more confused and some of the more impaired thinking that he had about his circumstance and who he is and all of that.
Dr. Otto, did you provide in your report, did you provide a professional opinion on whether Mr. Harness currently has the ability to rationally consult with counsel?
Uh, with respect to rationally consult with counsel, I did offer an opinion that I think that is a significant limitation, a significant impairment in his ability. And it's what I find most concerning about the defendant in this case
Yeah.
with
And did
respect to
you,
his competence related abilities. Yeah.
and did you offer a recommendation about his overall competency?
Yes, I recommended a disposition that the court consider, recognizing that it's ultimately for the court to decide. Of course, yeah.
And what was that recommendation?
I recommend that Mr. Harkness be considered incompetent to proceed. I acknowledge that he has a factual understanding of the legal system and its operation generally. He has a factual understanding of his rights as a defendant. I acknowledge that when he is lacking information about those kinds of factors, he's able to incorporate information when it's presented to him. I acknowledge that he understands his own situation, his charges, his the allegations, understanding his charges, and the sanctions he's at risk for receiving. I acknowledge that he understands that he's vulnerable to punishment and can receive punishment. However, I believe that his thinking about his case and his personal circumstances, his decision making about what's best for him in this case and what kinds of legal strategies should be adopted by you and him together, I think that is very much tainted or impaired by underlying symptoms of mental disorder, including confused thinking and delusional thinking and impaired judgment.
Thank you, Dr. Otto. No further questions, Your Honor.
All right. Let's make sure we get through the cross-examination, Anthony, and then we
Yep.
can leave time for discussion. We've got about 5 or 10 minutes after the hour.
All right. Dr. Otto, are there tests that can be used to help assess if a defendant is exaggerating mental illness?
Yes, there are.
What are they?
Do you want a complete list or some examples or
You can provide some of the most noteworthy to you.
the structured interview reported symptoms version 2, the test of memory malingering, the Green's word memory test, Green's medical symptom validity test, the inventory of legal knowledge, the test of malingered incompetence, the validity of Victoria's symptom validity test, uh, scales that are embedded within other tests designed to identify people who might be exaggerating and fabricating. So some scales, for example, like the fake bad scale of the MMPI-2, the F scale or the FP scale of the MMPI-2. I could go on.
That's not necessary. I appreciate you providing a lot. I don't recall seeing any of those noted in your report. Did you use any of those?
I did not administer any measures of response style in this case.
Why did you not use any measures of response style?
Given the defendant's presentation along with the report by defense counsel about impairments she was observing, along with how he was described in multiple medical records, I did not believe that I needed to formally assess his approach to the evaluation.
Even if you didn't feel they needed to, that you needed them, could they have provided you useful information?
If I administered them, they could have provided useful information. Yes, certainly.
So maybe there's missing information that if you had it after administering one of these would lead you to offer a different recommendation. Is that fair to say?
Although I can't exclude that as a possibility, I think it's unlikely for a variety of reasons. I think there's a general consensus in the field that among the most difficult symptoms of mental disorder to exaggerate or fabricate, if that's what you're suggesting or that's what you're concerned here, is impaired thought, what we call impaired thought form, right? Anyone can say, sure enough, I believe I'm the king of England. I believe I have 50 wives and all of that. I will point out, while we're on that topic, that not only did Mr. Harness report those delusional beliefs to me, but so too did his father, and so too were those delusional beliefs documented in a number of healthcare records that I was provided for review. So I don't dispute that I could have administered at least some of the tests that I listed out for you. I don't think they were necessary given the large amount of information I had in support of a claim that these were genuine symptoms that Mr. Harness has been struggling with.
On to Mr. Harness himself. Dr. Otto, on page 7 and 8 of your report, where it says he's been arrested more than once before, is that your recollection?
Yes.
So he's had prior cases, is that so?
Um, my recollection is that he reported to me that he had been arrested in the past as a juvenile and an adult.
Any
So I'm
indication
sorry.
that any indication he's been found incompetent before?
I had no data to that effect.
Any indication there's ever even been a question before your examination that he's been anything but competent?
I I have no data one way or the other.
Okay. Dr. Otto, in your opinion, does the defendant know and understand the charges against him?
Yes.
Does he know and understand the accusations underlying these charges?
Yes.
Does he know and understand that people can be punished for breaking the law?
Yes.
Does he understand that he could be punished?
Yes.
Does he know what it means to be on probation?
Yes.
Does he understand his rights as a defendant?
Uh, he has he demonstrated basic knowledge, some deficits, but he generally was able to incorporate and remember information focused on remedying those deficits.
And he knows the defense attorney's job is to protect the defendant and to help him.
Yeah, a little limited in terms of a deeper understanding of how a defense attorney might go about doing that, but he certainly perceived defense counsel as an ally. I agree with that.
And he didn't consider me an ally.
No, he understood you were trying to bring in evidence against him.
Does he know various pleas in their meetings and their meanings?
Yes,
Yes.
yes,
Um, was he able to come to an understanding that he must be, or was he, excuse me, was he able to come to understand that he must be proven guilty beyond a reasonable doubt?
yes.
Okay. Does he know what witnesses do?
He knew that witnesses provided evidence, and not only that, he identified people who are quite likely to be witnesses in his case.
Was he able to show some ability to talk about what was going on that got him charged with these crimes?
Well, he he offered a very basic account of what got him charged and arrested. Yes.
Was he
When
abs
when when asked to provide details, when presented with questions asking him to elucidate and expand, that's where he began to experience. That's where he showed more deficits.
Okay. Well, Dr. Otto, as a non-attorney, as you are, what is your understanding of the law? In other words, must a defendant's understanding and ability to participate in the legal process be perfect without any impairment?
No, no,
Can, can there be some limitations if there's enough ability demonstrated?
that's my understanding. Yes.
Okay. Yes, and maybe that's the case here. No further questions.
All right. Thank you. All right, very good job, Anthony. Any questions or thoughts about this little 25-minute display here? Uh, some of the questions Anthony asked, some of my responses, uh, questions you would have loved to ask, questions you think would be great cross-examination questions based on, the little you know about the case. Anthony obviously had the benefit of the report.
There was one question Anthony asked, and it was I think I've almost every time I've testified, it's come up, which is the um, did this happen? Did this really happen? Right? And your correction of, oh no, I said in my report that he told me this is different from me saying that I did that this is what happened. So if he reported this thing. Like essentially, I've had on cross. They go, "Oh, you say that he doesn't have a substance use history," and I go, "No, he reported that he doesn't have a substance use history," and that's something that I've at least seen as a very common tactic in cross is kind of almost overextending a little bit and requiring the expert to kind of walk it back and clarify the source of the information instead of kind of coming to that conclusion.
And is that what did Anthony do? I'm sorry. Are you saying that Anthony did that?
Yeah, yeah, he
Or
did that, and I was kind of like, oh yeah, no, I think I know where Randy's going to go with this one, and you handled it well.
yeah,
Um, but no, that was just something I've seen at least come up quite frequently, so I was kind of
yeah.
glad to see it in this exercise as well.
Okay, all right. There are some things that Anthony was trying to make as points. Like, does he know? Does he know what evidence? I think was that the question that you said.
Yeah.
What evidence? Yeah. Let me tell you. Not only does he know what evidence is, he knows evidence in his case. I'm going to embrace that, right? That's like almost like a judo move, right? Because I'm trying to be transparent. You're trying to make the point, Mr. Prosecutor, that this guy knows a lot. and therefore he should be found competent. Don't worry about all this. Well, he gets confused and he's making bad decisions about how he should plead. That doesn't matter. What really matters is he knows what guilty is and not guilty is. And so he's trying to make the, I'll help you make them, Mr. Prosecutor. Not only you're underplaying it. He knows what evidence is, and he knows evidence in his case. He knows who will be witnesses in his case. So I'm gonna do that because it's about transparency. You might say, well, why would you do that? Why wouldn't you just answer that question there? No, I'm transparent. I think you're missing some point. You can make some better points on me, Mr. Prosecutor. Let me help you. Or better points, let's say, you can make some better points in what your argument is, right? You can say, Dr. Otter, doesn't he know what evidence is yet? Doesn't he even know witnesses in his case? Yeah, but you didn't say that. I'll say it for you. Right? Because if you want to use that, ultimately, if the judge wants to use that to say this guy's competent and disregard my evaluation, well, fine. I did my evaluation. I formed my opinion. If the judge wants to use my report and my testimony to say, you know what, Otto, your competence bar is too high. Thank you for all this information. The competence bar should be down here. This guy's got enough, as the prosecutor said, or as you said when the prosecutor asked you. You don't need perfection. You're demanding too much, Otto. I'm the judge, so I'm going to say he's competent. Okay, all right. You are the judge. You're the person who sets the bar. Okay, but I think by writing my report and answering the questions, I did my job. And if my bar is different than the judge's and the prosecutor's, by the way, I think the prosecutor thinks he's good enough for government work. Okay, then find him competent and prosecute him. Right? I don't have a dog in that fight. My dog is that the prosecutor, the state attorney, the prosecutor, the defense attorney, and the judge know what this guy does and doesn't get. That's the fight I care about. Right? I don't care about the ultimate issue here.
And I'll highlight for some of our, particularly for some of our early career people here, not an uncommon thing on cross-examination. If you'll notice, as I started a little bit more accelerating, spitballing a lot of things that I knew that Randy would contend to. Yes, yes, yes. And then as it progressed, I might ask some more questions there that stretch out the abilities a little bit more than perhaps is as evident in the report, if only because I want you to get the accelerated feeling of, oh, this is the section where, okay, their motivation is to highlight stuff I've already contested to. But you still need to sit with every question I ask. Because even if you're getting so used to me saying this and I acknowledge this, but it might be subtly different than what you actually said. And so you really need to listen to each question, even if they're trying to rush you through each process there. And if you completely agree with it, a yes suffices. If you don't disagree, if you don't agree with a part, that's your opportunity to sit and clarify. But you don't want to get so caught up in all the yeses, you say a yes to something that you don't actually mean.
Yeah. I talked about this before we got started, and that was when you're hit with yes, no questions, whenever possible, if yes is good enough, stick with yes. I consider the resistance to the yes question, the yes, no question. And I know, well, let's be candid. I developed some of these questions, right? So I knew what was coming. So let's full disclosure. So I know what we're doing now. He's going to get me to acknowledge a bunch of stuff that I've acknowledged in the report, acknowledge a bunch of stuff, all the things the defendant can do and does understand in favor of his argument. Yes. When you're going to resist, that's when you're using your silver bullet. Well, not exactly. And let me tell you why it's not yes. You only have so many silver bullets, right? You can't oppose every yes question and look like, well, now you're being a little oppositional. right? So give up the yeses when you can on cross and save the opposition for the important points, right? So you got a lot of yeses, but it's the truth. He does have a factual understanding of a lot of stuff, and when I explain it to him, he understands it. He appreciates it. He gets it. He's a reasonably bright guy. Any other questions or comments at a Friday afternoon at 4:25? All right. So we are done. Anthony, do you want to make reference to our what we have in the chat right now?
I entered in there. There's the link to the CEU survey that you can complete to get your continuing education credits for this whole training. Make sure that you open that up now or save it, bookmark it for later. This stays open for roughly 48 hours, so unfortunately that then means it's weekend work. But or you can just go ahead and do it immediately now. And that'll be available for 48 hours and then save your certificate afterwards to keep your credits.
All right, we are officially done. Thanks to all of you for your attention last week and this week. And if you liked it, you can take it again in a couple months. I don't think I would wish that on anyone. But all right, goodbye, everyone. Have a good weekend. Thanks for doing this with me, Anthony.
Absolutely. All right. Take care, everyone.